Getting to be that time, and then you can have lunch. Alex, it's good to see you, my friend.
Good to see you.
I'm sorry, were you waiting? Hi.
Professor Manning. Call the bill.
Cleaned up nicely, so read my hopes.
Great. Okay. I'll leave one mine. Thank you. My coat. Okay.
See, these incontinent guys, they ran over. It's making it harder to reassemble everybody. All right.
Do we sort of touch gloves?
Jesse Jackson ran at the end of one debate, and people haven't forgiven him. What was his name?
All righty, we're going to get started now with our next panel. Welcome to everybody.
Let me calm down.
This panel is called Freedom and Virtue, the Conservative Libertarian Divide. And it promises to be sufficiently lively that you will not spend the next hour and a quarter just thinking about lunch. We have the great pleasure to have here today Professor Hadley Arkes. Professor Arkes has been a member of the Amherst College faculty since 1966, where he was the William Nelson Cromwell Professor of Jurisprudence, and since 1987 has been the Edward Ney Professor of American Institutions. He's written 5 books with Princeton University Press: Bureaucracy, The Marshall Plan, and the National Interest. That's one book. The Philosopher in the City, First Things, Beyond the Constitution, and The Return of George Sutherland. His most recent book, Natural Rights and the Right to Choose, was published by Cambridge University Press in the fall of 2002. Professor Arkes' articles have appeared in professional journals, and he has become known to a wider audience through his writings in the Wall Street Journal, the Washington Post, the Weekly Standard, and the National Review, where he has been a contributing editor. He is a highly thoughtful and influential analyst of and commentator upon American law and institutions, and we are delighted to have him here. Let me introduce Judge Kaczynski before I call Professor Arkes up here. Judge Kaczynski is an eminent jurist on the U.S. Court of Appeals for the Ninth Circuit. Born in Bucharest, Romania, and educated in Los Angeles at UCLA and UCLA Law School, Judge Kaczynski in 1985 became the youngest person appointed to a U.S. Court of Appeals since William Howard Taft. Barred by the Constitution from pursuing Judge Taft's subsequent career path, Judge Kaczynski has served almost 20 years on the bench, and in the process has built a record as one of the nation's most thoughtful, principled, and in some ways, and this is a high compliment, Judge, one of the hardest judges to pigeonhole in the country. He writes opinions that are analytically hard-hitting, but are written in user-friendly, conversational, and often witty prose. So at least you get a smile while he is ruling against you. He is an old friend of mine, and I am delighted to have him here. I will have Professor Arkes speak first for approximately 20 minutes, a limit that I will enforce laxly. And then I will give Judge Kaczynski 20 minutes. Then I will give them a few minutes for further glancing blows if they wish, and then I will open to questions. When I do take questions from the floor, I will ask you to identify your name and what institution you are from. And so without further delay, I give you Professor Hadley Arkes.
Yes, we will speak for 20 minutes. They've also kindly agreed to let me take 1 minute aside to recall that when I was here last, about a year ago, in this room, I just recalled that I was tempted to draw upon that clipping that my friend Michael Ullman had taken for me from the New York Times, from the Metropolitan Diary, Sketches of Life in the City. And one from 7 years back ran in this way. It said, "Dear Diary, it was midway during Act 3 of La Traviata by Verdi at the New York City Opera. And after witnessing Alfredo's confession of love, Violetta's rejection of the carefree life of Paris, their retreat to the countryside, Giorgio's appeal to release Alfredo for the benefit of his sister's prospects of marriage, Violetta's compliance and pretended deceit, Alfredo's jealous rage, her reversal, an illness, Giorgio's sympathy, the lovers' tragic reunion, and Violetta's death. After all of that, I heard the woman behind me say to her companion, "The same thing happened to my girlfriend Gloria." Now, I'd like to draw on the same blending of the grand and the prosaic in offering these reflections to you today. As my late leader, the first Mayor Daley, used to say, I offer these reflections for the enlightenment, the edification, and the hallucination of this group. This is a discussion long overdue in our circles, and I may say if we're going to have it, I can't imagine a more engaging partner to have it with than Alex. It's a discussion long overdue because for a certain libertarian temptation threatens to do for us what the lure of moral relativism and postmodernism has done for many liberals in our own day, which is to render liberalism and the claims of liberty incoherent. Liberals in our day invoke the claims of privacy while they relentlessly legislate to deny claims of privacy in the management of private corporations, small private businesses, private clubs. When liberals enacted the Civil Rights Act of 1964, there was no touch of moral relativism, but a familiar line among liberals of late has been to deny that there are moral truths or grounds of moral judgment, and they strike this posture, I think, mainly to fend off the temptation to cast moral judgments on them in their sexual lives, but all the while they remain free to keep legislating, to keep restricting our private lives in all other respects. That stance of liberals, that moralism without morality, that drive to keep legislating, may account for libertarians recoiling from people with a passion to legislate for others. But many libertarians have been drawn to the same fount of moral skepticism, and that moral relativism threatens our own side with the same kind of incoherence that afflicts the liberals. To condense my claims here, before I explain them, many libertarians have missed the anchoring point that the claims of liberty flow only to those beings Madison described as moral agents, that the libertarian argument is irreducibly a moral argument, that when we understand again the connection between the logic of morals and the logic of law, when we understand the serious moral requirements that must attach to the making of laws, we realize that we have lifted the bars for legislation. To understand the moral ground that alone can justify the law is to make it harder, not easier, for people to legislate. It is to firm up the protections of liberty, not to diminish them. From the beginning, Aristotle's politics, we understood that the defining mark of the polis was the presence of law, and law could spring only distinctly from that creature who had a capacity to give and understand reasons over matters of right and wrong. As the old understanding went during the time of the Revolution, we may not rule beings of that kind in the way that we can rule dogs and horses. So even today, even in this age of animal liberation, we don't sign labor contracts with horses and dogs, and we don't seek the informed consent of our household pets before we authorize surgery on them, but we continue to think that those beings who can give and understand reasons deserve to be ruled with a rendering of reasons in a regime that elicits their consent. Lincoln said of those slaves who did not throw in with John Brown that as ignorant as they were, as uneducated as they were, they still had the wit to see that the schemes of this crazy white man would not conduce to their well-being. Those blacks might have been unlettered, but they had the capacity to reason about the grounds of their well-being, and for that reason, they were not rightly annexed to the purposes of other men without their consent. In contrast, we don't have to give justifications when we clear cows off land in order to build houses. Claims of liberty flow distinctly to those beings who can reason about matters of right and wrong, but then the corollary. Those beings who understand the difference between right and wrong understand, as Lincoln and Aquinas said, that they cannot claim a right to do a wrong. And so they may understand the things they may not rightly claim, even in the name of their own liberty. So as James Wilson pointed out at the founding, contra Blackstone, even in the state of nature, we never had the right to murder or to rape. And therefore, the laws that restrained us from murdering and raping never deprived us of anything we had a rightful liberty to do. The upshot, contrary to Blackstone, we did not surrender our natural rights when we entered civil society. So as Hamilton says in the Federalist 84, here the people surrender nothing. We did not give up our natural rights on entering the civil society. So there was no need to reserve in a codicil or a Bill of Rights a list of rights we hadn't given up, for we'd given none of them up, and we didn't wish to install now the premise that we had given them up. This is the other part of the argument about the Bill of Rights that tends to be forgotten. John Stuart Mill said that we stop using the language like and dislike and begin using language of right and wrong, as we think that people may be punished for what they're doing. He caught in that rough way the difference between a statement of mere personal taste and something that stands in the class of a moral proposition. We move in moral judgments beyond statements of merely personal taste and private feeling to speak about the things that are more generally or universally right or wrong, just or unjust, for others as well as ourselves. If we come then to the judgment that it's wrong for parents to torture their children, we don't go on to conclude, well, therefore let them torture or not, as it suits their judgment. Or let us give them tax incentives to induce them to stop, or a DVD player as a premium. Hence, the traditional understanding of the connection between the logic of morals and the logic of law. That when we come to the recognition that any act, the torturing of a child, stands in the class of a wrong, we lay the groundwork for forbidding that act to people generally or universally, which is to say, we forbid it with the force of law. Now, that doesn't strictly mean that we are obliged to make anything illegal at once if we judge it to be wrong. Prudence may well enter with a sense of the wrongs that it may be impolitic for us to reach witut begetting evils even worse. But when we say that there is a moral groundwork for the law, we mean strictly that before we remove private choice and restrict personal freedom, this is where I think the libertarian perspective is built into the morals perspective. Before we remove private choice and restrict personal freedom, the law carries the burden of showing that there is something truly, in principle, wrong. That standard can't be satisfied merely by the claim that this policy reflects the strong beliefs of a majority. Even if a majority believes that stealing chickens is a genetically transmissible crime, that doesn't justify the legislation providing for the compulsory sterilization of the chicken thieves. And you know the case. Skinner. A majority moved by tenderness may seek to protect young lawyers, say, from working overly long hours in offices hazardous to their health. That's not good enough to explain why it is wrong for any particular young lawyer to work additional hours if he thinks it necessary for his case or his career. But as Rufus Peckham warned in Lochner, we could as aptly reach that kind of conclusion on the same loose reasoning that justifies restrictions on the hours of people who wish to work overtime as bakers. Alex and I are both defenders of Lochner. But quite apart from the beliefs or the passions of a majority, it does not meet the moral standard to produce a policy based merely on generalizations, even when those generalizations are quite unmistakably true and persuasive. I'd submit to you that we rarely encounter findings in aggregate data as compelling as the findings assembled years ago by my friend George Gelder on the plight of that hapless character known as the single male. That bachelors were 22 times more likely than married men to be committed to hospitals for mental disease, 10 times more likely to suffer chronic diseases of all kinds, that single men had nearly double the mortality rate of married men, 3 times the mortality rate of single women, that divorced men were 3 times more likely than divorced women to commit suicide or die by murder, and they were 6 times more likely to die of heart disease. Ladies and gentlemen, the evidence is unmistakable. These single men are massively at risk. The deliverance from this condition could have the most profound effect, not only in improving public health, but in actually rescuing lives. And yet we take it for granted that nothing in this set of data would furnish the ground for legislating on marriage by contravening the freedom of both the men and the women in assigning these men to brides. In the same way, the old Komen report told us that if we could keep the black population in any school below 29%, we could have the effect of raising the median reading score for black students by 0.09. But we seem to understand that if we cannot say in principle why this arrangement is good or just of necessity for any student, we don't have the grounds for contravening the freedom of any student by assigning these students explicitly on the basis of race to schools for the sake of meeting a racial ratio. In other words, when we take seriously the moral ground for the law and the moral requirements that must be met before we're justified in making laws, the result is not that we legislate more, but that we legislate less. For the bar has been notably raised. The standard is more demanding. Immanuel Kant warned in one of his more luminous moments that even a unanimity of feeling cannot provide the surrogate or the replacement for a moral proposition. For if the conviction rested solely on feeling, it was contingent on the possibility of that feeling passing away. Even if we were unanimous in our passion for the Coca-Cola and the frozen yogurt, we would still not have the ground for making the yogurt and the Coca-Cola compulsory. Right? So my friend Jim Wilson says that we can show people sonograms on babies in the womb at 8 to 10 weeks, and most people looking at the sonogram will say, that looks like a baby to me, and on that basis we might protect the child in the womb. But if the ground were simply what that looks like to me, there is no ground in which to impose the policy on the people who look at the screen and say, well, it doesn't look like a baby to me. Okay? It is not what it looks like that is decisive, but what it is, and why in principle it is untenable to claim that this being in the womb is anything less than a human being at any stage. Getting clear on this matter is getting clear on the point that we don't legislate on a matter of consequence, on the basis merely of perceptions, impressions, feelings, even if those feelings were massively and widely shared, rising to the point of unanimity. Nor would the standard here be satisfied by empirical predictions merely contingent in nature. If Saks Fifth Avenue moves into the neighborhood, the whole neighborhood will prosper. That may be true, but even if it were true most of the time, it would not be true of necessity. Whether it is true or not, good in its effects will be contingent on many other things, probabilistic in nature, and therefore problematic. There's a striking difference between that kind of a proposition and something closer to the proposition that Thomas Reid offered as the first principle in legal and moral reasoning, which I'd render in a slightly different way, that we cannot hold people blameworthy and responsible for acts they were powerless to effect. There are no contingencies under which that proposition will fail to be true. Its truth will be utterly unaffected by the question of whether its recognition in any case will bring good or bad results. And yet that proposition may explain quite a bit of the ground of our law in things like the insanity defense, or even in part in the wrong of racial discrimination. In striking contrast, so many of our judgments in the area of civil rights have been put forth as so many contingent propositions. And so, for example, if blacks could not attend the same law school with whites in Missouri, if they had to take vouchers to attend schools in other states, then the argument ran, they could not make the connections useful to their careers in the law. But it does not follow, as a matter of necessity, that any black student in the school will have conversations, form friendships, and make connections leading to a rising career. Cecil Partey, the late black ward committeeman in Chicago, graduated near the top of his class at the University of Arkansas in 1938, but he was barred from attending law school in Arkansas. Instead, he was given a voucher to attend schools out of state. So barred from the law school at the University of Arkansas, He had to choose instead between Northwestern and the University of Chicago. He said, I laughed all the way to Chicago. He did not suffer a material harm as a result of being turned away on the basis of race, but he was wronged. He was treated according to the maxims of an unjust principle. Was it in principle wrong, then, to separate students on the basis of race in the schools, or was it merely contingently wrong, contingent on its effects on the performance of the students? So that if we separated the students on the basis of race and their reading scores went up, would the segregation have ceased to be wrong? Lincoln famously said that as I would not be a slave, I would not be a master. Since he rejected slavery in principle, his rejection of it was utterly indifferent to the question of whether he stood on the advantaged or the disadvantaged side of that relation. And with that sense of things, we then ask, well, is it in principle wrong to assign benefits and disabilities to people on the basis of race? Or is it merely contingently wrong, contingent on whether it creates benefits for racial minorities and disabilities only for whites? Our policies on racial preferences and affirmative action show the result of this moral confusion accumulated now over the years. When we apply a more demanding moral test, it is not good enough that something be merely contingently right or wrong. The question is whether it is wrong in principle, say, to discriminate on the basis of race. That is a test of a categorical proposition, and it's a demanding test, but not inscrutable. It arises for us when judges of ordinary wit raise the simple question, is it necessarily true that? Is it necessarily true that it is wrong to have children instructed in German, and so legitimate for a legislature to ban the teaching of children in German? Myers versus Nebraska. Or as we hear today from gay activists, is it necessarily true that every married couple will beget children, and that marriage should be confined to the couple capable of begetting? By insisting on that question, the activists may not realize that they are installing as the requirement of the law that the law answer to the question, is it necessarily true? They are insisting on a categorical proposition as the ground of the law. To that I say, you've got it preeminently right. But installing that premise will undo their arguments because it becomes legitimate in turn to raise questions cast in principle, and in my judgment, those are the challenges that the activists at this moment cannot meet. One of the enduring sources of confusion among people who banter over moral judgments is that we cannot cast absolute moral judgments in terms of any empirical thing or activity. Forgive me for citing Kant once again. Michael Moore and I will set a record on this. But as Kant recognized, anything we can name, even the most prosaic of things, name anything, hitting golf balls, driving cars, anything can be part of a means-ends chain leading to a wrongful end. We can use the skill of driving to drive for the mafia or to drive an ambulance. We cannot say that it is wrong under all circumstances to kill your mother. She may be a terrorist trying to kill you. And goodness, there are enough women in this country, enough mothers willing to order up the killing or the deaths of their offspring. We speak about the things that are categorically or unconditionally right or wrong only in terms of the logical maxims underlying our acts. At times, those maxims have been woven into the aphorisms of the law and taught by our great jurists. The presence of a wrong implies a remedy, justifies a remedy. We should visit punishment on people only when they are guilty of wrongs. And we should respect the difference between innocence and guilt by committing ourselves to making that discrimination only in the most direct, demanding way, with the canons of reason testing evidence, rather than having people outrun mobs in the street. Okay? Justice Story reminded us that what we may not do directly, we may not do indirectly. If it is wrong to kill Jones, it is wrong to hire someone else to kill Jones. And if the government may not reach that subject directly, it may not use the tax system or the spending power as a covert way of reaching the same result. This maxim is likely to be invoked if we sought to bar the funding of partial birth abortions, even as the courts are holding that Congress cannot bar that surgery directly. We're likely to hear people say, you're trying to reach through the spending power, which you cannot quite accomplish through legislation. We don't know the moral significance that comes along with driving cars or using computers unless we know the end to which the activity is directed. For the same reason, we cannot pronounce a judgment on the categorical innocence of anything that takes place in the domain of privacy. A murder in a bedroom is just as much of a murder as a murder in the public streets. And the law may reach, as you know, the most private places, even people storing heroin in condoms placed in body cavities. And that is what is so mindless and corrosive of the mind in those glib formulas that suggest that anything taking place in private settings is insulated from moral judgment, or that the law cannot cast moral judgments on sexual orientations. The term is so abstract that it covers bestiality or sadomasochism. And there's the strongest overlooking of the fact that even gay activists find certain orientations that they regard as illegitimate. It's been a point of contention for years as to whether the gay pride parade in New York will include the North American Man-Boy Love Association. Even gay activists suggest that there's something not quite legitimate about that orientation. And by the way, as an aside, ordinarily we allow parents to give their consent for involvement of their minor children, but even the libertarians do not seem inclined to permit parents to give their assent to a sexual relation between a teenage son and a male teacher. And yet, if there is nothing illegitimate about homosexuality, well, why would we interfere with the freedom of a parent to let his child be introduced earlier to a way of life that he regards as legitimate? But on my main point, if we can cast judgments on certain sexual orientations, we have to recognize then that there is simply no ground for the legislation that would bar in a sweep all discriminations based on sexual orientation. So if we had to stop using that term in the laws, the activists would have to say more precisely what they mean and what they would forbid, and that becomes harder than we might suppose. Because it would be quite implausible to say, for example, that we don't cast moral judgments on people in the way they achieve orgasms. There's the matter, obviously, of rape, but even things that are not so obvious. For our legal judgments are not all cast, let me remind you, in the criminal law. Statutes on adultery are almost never enforced, and yet people have lost custody of children because of a pattern of promiscuity, suggesting a want of fitness as a parent. In Lawrence versus Texas, Justice Kennedy suggested with a sweeping language that the law must recede from casting moral judgments on certain intimate sexual practices taking place in private. Just about every conservative I know would have held back the law or repealed the criminal law on sodomy in Texas. And yet, may I say, it marks a flight from sobriety or any faintly rigorous juridical sense to say that the law may never cast an adverse judgment on sexual practices taking place in private settings. If we had men seeking to be adoptive fathers, it could make the most notable difference in the weighing of their claims if they happen to be committed members of the National North American Man-Boy Love Association, or people quite openly committed to sadomasochistic sex. And I think you'll find that even judges who shy away from moral language may find reservoirs of judgment as they find quite plausible grounds to believe that a man committed to sadomasochism, containing in his house whips and chains and other fearsome devices, does not project in principle a wholesome ethic for the nurturing of a child. To take a line from Henry James, Justice Kennedy is the victim of perplexities from which a single spark of direct perception might have spared him. For a man rather seasoned in the law, he has shown a strange willingness to be seduced by airy cliches and to pronounce moral judgments while utterly detached from any grounding in moral substance. The corrective is not to ban from our reasoning and our judgments a distinctly moral perspective, for in that path lies incoherence. The main remedy is to get clear again about the moral ground of the law and to remind ourselves of how rigorous, in fact, the test must be before we pronounce on the things that are categorically right or wrong, and before we act then through the laws to restrict personal freedom. I'd rework then, in closing, an old line of Woody Allen's and say, ladies and gentlemen, there's no question that there's a moral world out there. The only question is, how far is it from Midtown and how late does it stay open?
Whoa. Since Professor Arki started with a story, I'll start with a story too. The story about the new rabbi at a congregation. And it was a very fine congregation. Everything went swimmingly, except there was a problem. Every time the congregation came to recite the Shema Israel, half the people stood, half the people sat. The people standing would say, you'd yell at the people who are sitting, saying, stand up. The people who were sitting would yell at the ones standing, saying, sit down. And there were arguments all the time about it. Those who wanted to stand said, the Shema Israel is the greatest, it's the greatest prayer Jews can give. They've recited for millennia. You have to stand for that important prayer. Others pointed to the Talmud, and there were passages in the Talmud that said, no, when you get to the Shema, if you're already sitting, you remain sitting. Well, couldn't be resolved. And finally, the rabbi learned that somewhere in an old age home, there was an old rabbi who had been there at the beginning of the congregation. He was 98 years old. So he took a delegation with him, one of the standers and one of the sitters, and he went to the rabbi and the old man in the restroom, and they asked him. The first guy said, the stander said, now isn't it true, isn't the tradition that you stand? Wasn't the tradition in our synagogue always that you stand during the Shema? And the old man says, no, that was not the tradition. So the sitter says, that's right. Wasn't the tradition that you sit during the Shema? The old man says, no, that wasn't the tradition. The rabbi says, listen, just pick one. Do you know what happens now? People stand, people sit, they shout at each other. There's chaos. The rabbi says, that was the tradition. On questions of morality, on questions of virtue, by and large, those of us who live in Western society, especially those of us who live in the United States, can agree on the main points. And the problem is the devil is in the details. What is difficult about deciding about morality is that people don't agree what the tradition is. On very fine points, people do not agree what is moral and what is virtuous. So libertarians, and I will speak here for the libertarians, and I hope I represent them adequately, view the object of government as a much more limited one. We do not try to plumb the depth of human morality in every way. What we believe government really has a proper objective that's much more limited, and that is to keep people from hurting each other. That's it. To keep us living in a society from taking each other's lives, from taking each other's property, from doing harm to one another. It's a limited objective. It's a hard enough objective for government to carry out, because even as to that, there's disagreement among reasonable people. What it is to hurt another human being, what is another human being, when is somebody old enough to undertake the responsibilities of a human being? Those are all hard questions, but in the end, it limits, libertarian philosophy limits as to that question. And that something is justified. So governmental action, governmental restraint on individuals is justified if seeks to prevent harm. If it doesn't, it is not justified. Now, libertarians do not turn their back on morality. We do not consider ourselves amoral or immoral. We simply believe that morality is not the object of government. Morality is something that is practiced individually, personally, in the home, taught parent to child, member of the church or community or synagogue to other members. It is not something that government can legitimately pursue and ought to legitimately pursue. Doesn't make us immoral. We simply limit the political sphere to those objectives or things that government can pursue properly and without undue interference with people's development as human beings. Now, let me get down to concrete. Let me talk about a couple of cases. The problem what happens is when government goes beyond those aims and it seeks to promote morality, it winds up. Well, first of all, I want to reiterate the point made by Professor Fried and Professor Knick early in the seminar, is you can't really have virtue if it is compelled at the point of a gun. If you must do something, there's really there's no virtue in actually doing it. So insofar as government tries to promote morality, insofar as it tries to use coercive power at its disposal to force people to do the right thing, it winds up being no virtue at all. You're required to do it. Now, of course, much of our law is based on morality because morality, as we understand it, reflects common understanding, common experience. So we generally think it's immoral to kill. It's also unlawful to kill for much the same reason. But what happens when government steps out of the role and tries to push a moral agenda? Let me discuss a couple of cases. And I want to be very careful to say I'm not going to discuss the legal merits of the cases because I'm not allowed to as a judge. But I just want to talk a little bit about the cases and what brought them about. One of them is a case that the Supreme Court just granted cert on for my circuit, and that's the Oregon assisted suicide case. It was called Oregon versus Ashcroft in the Ninth Circuit. It must be Gonzalez versus Oregon in the Supreme Court. And it's a very interesting case because again, I'm not going to speak to the merits of the case at all. That's up to the Supreme Court. But the way the case comes about is that Oregon, on two occasions, once in 1994 and again a couple of years later, passed an initiative that authorized doctors in the state to assist people to commit suicide under certain circumstances. It told doctors in the practice of medicine, you may help patients who are terminally ill and subject to certain constraints that they help them end their lives. Twice the voters of Oregon passed that statute. The Justice Department looked at it under Attorney General Reno and decided there was no basis in federal law for contravening it. When Attorney General Ashcroft became Attorney General, that policy was reconsidered, and the federal government instituted a policy that said that any doctor in Oregon that prescribes Schedule II drugs to help somebody end their life will lose his license to write prescriptions. Now that's a death sentence or that's the end of somebody's license as a physician. They take away your license to write, your ability to write prescriptions, that you simply can't be a doctor. So what the federal government was saying is that if you follow the state's policy, the policy adopted by the people of the state of Oregon, and you help an individual who seeks to end his life, if you do that, we, the federal government, will take away your license. You will no longer practice as a doctor in the state of Oregon. Now, again, the legal merits of that will be considered by the Supreme Court, but consider the implications of that. It's a policy that, first of all, runs counter to all notions of federalism. the idea that the federal government ought not to get involved in matters of local concern, matters involving the doctor-patient relationship, a value that this administration and those of us committed to a textualist view of the Constitution really hold dear. The idea that there are powers that the federal government has which are limited. The states have much broader powers, particularly when it deals with things like the the relationship between doctor and patient. That went by the wayside. The idea that we use the states as a laboratory, that some states will have laws and other states will have different laws, and we'll be able to study them, see which one works better, and learn from each other, that idea went by the wayside. The idea that we are a government, that the federal government is limited by the Commerce Clause, which is also an important idea, one that the Supreme Court has brought back in the last few years, that the federal government really ought not to use its powers to interfere with purely local matters. That went by the wayside. All these policies and of course, by doing that, it condemns some individuals in Oregon that the state had said are entitled to end their life. It condemns them to a lingering, painful, sometimes expensive and demeaning death despite their wishes. That is another consequence of this policy. Now, one can have different views about whether it is proper for individuals to end their life under the circumstances outlined in Oregon. And I think many of us would think that's wrong, that Oregon was mistaken. Oregon made a bad judgment in giving doctors that power, for many reasons. And yet we could say that there are principles in the way we govern ourselves that are really quite important. Things like federalism, things like the idea of a limited government, and that no matter how strong our feelings are about the morality of what the people of Oregon are doing, is that it is their problem. It is something that's a problem that's limited to Oregon, and the consequences of the bad policy, if it is a bad policy, will fall upon the people of Oregon, who can then, through the political process, change it. Now, if you're committed to these ideas, if you're committed to a structure of government that respects states' powers, that respects the Commerce Clause, that respects the idea of the personal relationship between doctor and patient, and the importance of that relationship being governed at the local level, then no matter how strong your feelings are about the morality of assisted suicide, you should not use the levers of federal government to interfere with it. Let me mention another case. And the point there is that the problem with using morality as the basis, the sole basis, is that it gives you a feeling that everything else can fall by the wayside. That once you've got God on your side, things like the Commerce Clause and trivialities like division of powers and the like are really not all that important, because this case is different. It involves morality. There was another case. There is a case now before the Supreme Court involving medical marijuana, but we had. I'm not going to talk about that case. I'm going to talk about a case called Conrad versus Walters, and that was a case out of California where the Attorney General threatened to take away the license of doctors who either prescribed or recommended marijuana for medical purposes. Now, understand, this is the same license, the license to write prescription medicines. But in this case, it was not a situation where the doctors were writing prescriptions. The situation is that a patient comes to a doctor with glaucoma or multiple sclerosis, and the doctor says, you know, I think you've tried other kinds of pain treatments. I think marijuana might be a cure for you, might give you relief. According to the federal policy, a doctor making that statement would stand to lose his license to prescribe. to prescribe drugs. And the reason it is that under California law, if a doctor makes that kind of recommendation, the patient can go out, get marijuana, and has an exemption from state law, from state marijuana laws. Cannot be punished under state law. They can still be punished under the federal law, subject to what the Supreme Court will say this term, but the doctor's advice winds up becoming an exception to state law. Federal government, our federal government, comes in and says no, even making that recommendation that gives an exemption to state law winds up being a basis for taking away the doctor's license. Now, it's hard to imagine the justification other than some moral sense that any reliance on drugs is a bad in itself, that somehow the federal government needs to get involved. It interferes with the doctor-patient relationship, interferes with speech. The doctor is simply giving advice to the patient, saying nothing else about not writing a prescription, not procuring the drug, just saying, I think this will help you. The federal government gets in there and says, no, you say that you can use your license. Now, many people think, gee, medical marijuana is sort of a fad. It's something that you have out in California. It's no rational person would believe in it. Well, that's what I used to think until I read this case, and it turns out there's quite a bit of authority out there that for some medical conditions, multiple sclerosis, glaucoma, some forms of cancer, AIDS, there's a variety of illnesses and disabilities where it turns out marijuana smoked through cigarettes winds up being the best form of relief that cannot be obtained from anybody else. Now, is this a fact? I don't know. I'm not a doctor. I know that the British House of Lords came to this conclusion. I know the White House, after California passed an initiative, had a report done by the National Institute of Medicine of the National Academy of Sciences, and they said, yes, that's right. Canada made findings and said, yes, in some circumstances, marijuana can help patients relieve their suffering, relieve their disabilities. And perhaps the best proof is, even today, as we stand here, there are a number of people in the country who, by mail, get 300 marijuana cigarettes a month from the federal government. That's right. The federal government ran a program called the Compassionate Care Program, where it experimented with this very question. And people that got on the program and whose doctors say you need to continue on the medical marijuana get, I don't know whether 8 or 18, there's some limited number of people in the country who actually get supplied a quantity of marijuana cigarettes by the federal government. Now, I find it unconscionable that the federal government would seek to interfere with this kind of, when the voters of California and 6 other states, Maine, Nevada, Alaska, Washington, Oregon, I forget what all the states are, have voted by initiative to allow this kind of relief to the people who in the states who suffer, for the federal government to use highly tenuous powers over their ability to write prescription to threaten doctors, to put them out of business as doctors, in order to keep them from practicing medicine, because the Attorney General of the United States feels it's somehow morally wrong to use marijuana for medical purposes. All this will do, because of course the penalties for marijuana in California are very low, it means that people who think they might be helped by marijuana, it'll get them to buy it on a street corner. And if we do know one thing about marijuana, is the powerful drug. And if you are sick in particular, you should not take it without the help of a physician. You should not take it unless a physician prescribes it for you and tells you how much to use, because you could make things worse. So by interfering with the physician's advice to the patient, we're not going to keep people from smoking marijuana when they are retching, when they are in extreme pain that morphine can help or the other things they can get from their doctor, it's not going to keep them from buying it. What they're going to do is they're going to buy it on a street corner, and they're going to use it as best they can, or as best they can figure out from the internet as to what the proper dosage is. Now that's the kind of incomprehensible judgment that seems to be made when the objective is some sense of overweening morality. We're going to do things because we know better, because we are acting in the name of truth, in the name of God, in the name of some higher authority. The objective of figuring out what conduct causes people in a society to hurt other people is hard enough. It's hard enough for us to figure out. We have enough disagreements on that subject. For us to try to inculcate some sense of morality, what some people, the people who happen to be in power at the moment, believe their sense of morality onto the rest of society, it's really folly, and it leads to all manner of really bad and unjustifiable results. I think that if we can achieve the libertarian objective effectively, I think this is we should consider ourselves quite lucky, and indeed we are. Thank you.
Thank you both. I will ask our panelists, would you like a couple of minutes to rebut? Okay.
Well, shall I use this?
If you'd like, sure.
Okay, all right. As a colleague of mine says, we could be in heated agreement. Holmes used to say of Peckham, of Rufus Peckham of Lochner fame, that his major premise was, God damn it. And it was amazing how serviceable that premise was. That, as the social scientists say, it could probably explain 85% of the variance. Now we look at this and we suspect, behind this legislation is a rent seeker. Somebody trying to make use of public authority to serve, and I think that's a properly healthy perspective that reinforces our sense that when we start legislating to restrict people, we have to have something of real moral standing before we do it, and we make it more severe. At the same time, let me remind you, in the tradition of prudence, Aquinas said, we don't press down on the multitude of imperfect men the burdens of those who are already virtuous. The purpose of the law is not to eradicate all evil, because we cannot eradicate all evil from these creatures midway between animals and angels. The purpose of the law is to compress evils to within tolerable limits. We all understand that. But at the same time, we understand that when we are legislating, strictly speaking, when we are displacing personal freedom and private choice, we cannot do that coherently. If we're simply saying we're imposing the strong passions of most of us on you, or our calculations of utility, we've got to come up with a better moral argument. I haven't sorted out that question of federalism. I may be with Alex on this one, but I'd simply point out that first, the one we are legislating, we are speaking prose all our lives. We must speak in the accents of a moral judgment. Now, Doug reminded us this morning about unalienable rights, the understanding of those things we are not authorized to do even to ourselves. We often confront in the moral sciences the incoherent rights claim of the biped who runs up saying, I have a right to believe I don't exist. And we say, who is the bearer of that right? You know? I have a right to kill myself because I believe I don't exist. It's an incoherent rights claim. We understand that when I say I can kill Jones, it doesn't establish that I have a right to kill Jones. So when somebody tells me I can kill myself, that doesn't translate into I have a right to kill myself. We want to know what's the ground of the claim. If the claim is I have a right to kill myself because I believe I don't exist, it's an incoherent claim. We're not sure we can honor it. If we understand there's certain kinds of non-moral attributes that were never justified in punishing people because of their height, their weight, their degree of disability, their deafness, Down syndrome. We understand that nothing in those features establishes that we're dealing with a good man, a bad man, somebody who deserves punishment. So if somebody tells us, I want to kill myself because I'm deaf, and a life of deafness is not a life worth living, I don't think we can acquiesce in that as a rights claim. A nurse came up to me once in Urbana saying, now I see the problem. I have patients who say, if I claim that I have a right to kill myself because I have AIDS, I establish the point in principle that when we establish someone has AIDS, we establish the ground it would be justified for anyone else to end his life if he's not in a position to do the same thing. We take on the logic of rights. There has been no more local law in our system than family law arranging for the custody of children. Until it suddenly broke in on us during the 80s when we found judges unraveling marriages, mixed racial marriages, assigning the children by matching the color of the children with the parent. And finally finding some black men who were losing custody because the judges decide, even liberal judges like Alex Holtzman in Washington, deciding that it's disadvantageous to be associated with a black parent, so that on the basis of color, one was losing custody of one's children. At that moment, it seemed to break in on us that even the most local law could be affected by the fundamental principles we're articulating in our basic law. Stephen Douglas was all for leaving those serious moral questions of slavery to the separate territories, but when it came to polygamy in Utah, there he was willing to send in the troops, right? If it turned out that we were being faced with question of people taking their lives because they are of the wrong race, the old problem of the conscientious Nazi, I think we'd have a hard time acquiescing in it, and we might even think that a federal policy that engaged permissions there might be doing something that began to tread on the deeper commitments of our fundamental law. But I say this with no prejudice to the answer. I'll keep this as an open question.
You know, all I want to add is that the fact that our law has roots in morality, or many of our laws are conform with what we think is moral, does not mean that the two are the same. As Hadley said quite clearly, a society can find something is immoral and yet not prohibited. At the same time, there are lots of things a society can prohibit that are not immoral. It's not immoral to drive 50 miles an hour in Harvard Square. It's not. I mean, it's a bad idea. It could hurt somebody, but there's nothing immoral about it. There's nothing immoral about putting a plane in the air that doesn't have an FAA airworthiness certificate. And yet we prohibit it because it's dangerous, because we have a procedure that ensures people's safety. So there is a relationship between law and morality, but there is not by any means a total overlap. Now, on this question of suicide, the Supreme Court earlier, a few years back, considered another case from the Ninth Circuit, a case where we held my court held that there is a constitutional right to commit suicide, that you are entitled to have your life terminated under certain conditions if you're in pain and so on. Supreme Court said no. The Supreme Court said no, you do not have a constitutional right to suicide. There's no, this is a matter to be worked out by the people of the state through their political process. The case I was talking about does not deal with anybody invoking a fundamental right to suicide. It deals with a judgment made by the people of Oregon that they believe they would live in a better society in Oregon if they allow certain people to take their own life. Now, as I said, many of us, perhaps most of us, perhaps even everybody in this room could be firmly convinced that it's a bad idea. I think it probably is a bad idea. I think there are many reasons why that kind of law is pernicious. But the question is not whether you have some fundamental constitutional right to it, but the question is whether or not, given our form of government, given what we firmly believe the way our union is organized politically, which is to leave decisions like that to the states and the local authorities, to the people governing themselves at the local level, is there a justification? Is there some sort of moral imperative that says the federal government has to come in and second guess and negate that judgment? I submit not. And I submit when we go down that road, then whoever happens to be in Washington will, what did Thomas More said to have said, will cut down every law to go after the devil. And then, you know,
Right.
when the devil turns around, there will be no laws left.
Okay, thank you both very much. We have time for probably 2 or 3 questions, if there's anybody interested in approaching the microphone. Great, and please identify yourself and what school you're from.
Misha Tsaitlin, Georgetown Law Center. Since the baseline of moral judgment is that one rational being cannot deprive another of his liberty without either his consent or proper justification, can't Judge Kaczynski's statement that government is established to keep others from hurting each other, if reworded on the proper moral ground, cover the field of moral justification, bridge the conservative-libertarian divide, and give us essentially a natural law foundation for a libertarian state?
Whoa, it's a lot.
Sure. I agree with you, so I'm not going to say anything else.
But Misha, I gather you were encompassing what we were both doing, I gather. Or, okay, all right. So we are in heated agreement, you want to say?
I should hope so.
Okay, all right, okay. Mr. Presley.
I wanted to comment a bit on comments of both of you. I had trouble in Professor Ark's account talking about there needs to be something of real moral standing when we're making these rules. The government should goal of government suppress evils within limits. And I think Judge Kaczynski's point about limited government, I mean, one of the great Lockean moves was, before people thought, well, if religion's a source of morality, as it was for most people, then how can we not make it central to the state? We have to promote the one true religion. By taking religion out of the state for most purposes, the idea was that the state didn't have to be the source of all morals, or even of one of the chief goals of morals. And the focus on the right to kill yourself or to withdraw treatment, focuses, I think, in the wrong place. Where does the state get the right to tell you whether you have to continue to be treated or continue to be taken care of? I can understand why you say the Constitution doesn't necessarily establish a right for individuals to do something, but where does the state get the right to override individuals' interests?
Well, I guess we use state when we think we're hostile to the notion, but when we think that the law is offering protection, then we invoke the notion of law. That if we take seriously the notion of unalienable rights, a notion that the courts will not uphold contracts where people contract themselves into a state of peonage, we say, no, you're not competent to make a contract of that kind, and the law will not be engaged to enforce it. And we say, well, what is this? In all these instances, why is the state intervening when you're putting the kids in Fagin's School of Pickpocketry? But if we think that it's a situation where the law ought to extend its protections, then we say, there's a ground of principle by which anyone with the authority to intervene should intervene, but we focus that authority in the agencies of the state that we call the law. The question came up last night of, why would I interfere with anyone's freedom except for my own freedom? Well, we may interfere as somebody is going to the rescue, trying to rescue someone from a mob, and his own body, his own self-preservation is not at stake. And the whole thing, the law of rescue, can be justified only because he is going to the aid of a victim. And when the question is put forth in, say, moral terms, for whom would it be wrong to assail that victim? The answer would be anyone. For whom would it be justified to resist? I guess the answer would be anyone. if we're dealing in the days of Cicero's Italy, there were no police forces. It takes a moral step for us to get to the point of saying that little old lady on the street has a claim to protection that should not hinge simply on her own powers to resist assailants. And then we say, who would have the authority to interfere, to protect her? I think what we're doing is putting all layers of moral propositions into place that finally explain why those agencies we call the law, and what Aristotle say, the law is reason without passion, why the law, something called the law, could extend its protections over the innocent. I'd work at it that way.
Can I take a stab at it? You know, I think the question you asked is an excellent question, but in a sense trivial, because the situation where you can take your own life, basically the law can't touch. If you are able to do yourself in, you're going to do yourself in, and that's the end of it. So yours is an excellent question, but it never really comes to a practical resolution. The case we deal with is where you can't do it yourself. You have to invoke the help of another human being, another doctor, somebody who is licensed by the state, somebody who gets drugs through a process that we regulate. And I believe that is enough of an involvement of societal machinery where the state can and should make a judgment as to whether that is an appropriate thing to do. And that's where I think the state's authority comes in, to decide whether somebody who is a healer, somebody who is trained to heal, to keep people from dying, of curing disease, whether we should take this person and turn him into a killer. I think that's a legitimate question.
But you jump from the situation in which you can't take your own life to one in which you need to be given active death, which is what's raised in the case you were talking about.
Right.
But the intermediate position, which was also before the Supreme Court in the late 80s, was the situation where the family simply wanted to withdraw treatment and let the person die. That doesn't require, that requires another person, but doesn't require the doctors to do anything other than stand by and not take action. And if you know that that's what the person wanted.
I believe Glucksberg is a case you're referring to, and I think that involved actually adding something, not simply withdrawing hydration and nutrition. Right now is permissible. You just shut off the machine. If you, I believe what happens is
case out of Missouri. No, it was the Missouri case.
Cruzan.
And that was one where they just wanted to take her off the ventilator, and the state of Missouri objected.
But you know, we shouldn't leave that without recalling our friend Scalia leaning in that case and saying, just a word of guidance for you people who are running ambulance services and emergency services. If you go to the rescue of someone who sought to commit suicide and you revive him, we just want to alert you, you're not in danger of being sued under 42 U.S. 1983 for depriving this man of his civil right, namely his right to die. And that's one of the hazards put up about making the move too casually to enfolding this as a right.
We have time for one more question, but before we do, I'm going to ask Tessa Platt to come up and make an announcement about lunch and some other matters.
Thank you, and thank you to our panelists. I just have two quick announcements. First, following this panel, there'll be lunch in the Ropes Gray Room, which is where the reception was yesterday. So we'd like to invite you all to come there. Or there are a number of really nice restaurants in Harvard Square if you want to enjoy lunch there. Just be sure to be back by 1:30. And second, if Peter and Sarah could come up. Peter is the director of the Federal Society Student Division, and Sarah's the assistant director. And we just wanted you all to meet them and thank them for all their support this weekend.
The person we should actually be thanking is Tessa Platt, who's our symposium coordinator.
Yay!
I think a lot of people think that the national office puts on the symposium, and it's really done by the host chapter, and Tessa has done a remarkable job. The chapter has done a remarkable job, and just if we could get another round of applause, and from the people downstairs as well.
Okay, final question, and please state your name and affiliation.
I am Henry Magram at St. John's College in Annapolis. In the last discussion, it was said that slavery is not debatable at one point, but of course in ancient Greece, and as we read in the Politics of Aristotle, it isn't the case. In fact, there is the just rule of the greater being over the inferior, as he says, man over wife in the household, and then in the Republic of Plato, the naturally greater contemplators, the guardians of the Republic, who are select and few over the masses. And this is towards the productivity of the state. And of course, today, as or recently, as Lincoln said, he would not be a master or a slave, although I'm sure he thought of himself as a contemplative man. So society now and then is greatly different. How do you feel about what Lincoln was saying in the way of his moral views of slavery that, of course, Aristotle wouldn't have shared, since Aristotle believed that greater thinkers should rule as masters?
Things change.
Look,
You know, you know, we want to think of morality as static, as having been with us in the birth of time and continuing. It's not. Things change. Life changes. Our perception, technology changes many things. The questions that didn't exist 100, 200, 300 years ago are now central to our lives. So the idea of viewing, I mean, much as I respect Aristotle, taking the view that he expressed in his time as being somehow controlling on us, I think is, I just don't think it'll fly.
Let me reinforce that from another angle. We know that at the time the 14th Amendment was passed, Lyman, Trumbull, and others assured their colleagues that, of course, nothing in that amendment would interfere with the laws on miscegenation in the separate states. And they knew that if they couldn't offer that assurance, there was no way that the 14th Amendment would be passed. But now we could come back and say later, look, if you understand the principle contained there, we can fill out the record, and there could be an implication that went unforeseen. But then again, we recognize that the whole experience of the moral life is that we become aware of implications in those principles that have heretofore gone unforeseen. I take notice of the fact that we are in Massachusetts, and in this state, if they shed now their inhibitions on polygamy, we're on with this new policy, I could marry Alex.
Well, I think that's a good note on which to close. Thank you very much, Professor Arcus and Judge Kaczynski.
Oh, it's nice. Yeah, I'm